video, we're going to talk about conflicts of interest. The Code of Professional Conduct prohibits lawyers from acting or continuing to act for a client where there's a conflict of interest, unless it's permitted by the code. The code defines a conflict of interest as meaning the existence of a substantial risk that the lawyer's loyalty to or representation of a client would be materially and adversely affected by the lawyer's own interest or the lawyer's duty to another client, a former client, or a third person. So what does that mean? The first thing to recognize is that if one lawyer of a firm has a conflict of interest, the entire firm usually has a conflict of interest. There are three common scenarios to avoid. One, you don't want to represent one client against a former client. Two, you don't want to represent two or more clients with differing interests. And finally, you want to ensure that the lawyer's own business and personal interests don't conflict with the client's. Lawyers typically obtain confidential information when working with their clients. Because of this, it would be very difficult for a lawyer to act against that client in the future without it appearing to be a conflict of interest. And again, all lawyers of the same firm are deemed to have the same knowledge. So even if it was a different lawyer at the same firm, they could not act against a former client of the firm. It's common for multiple parties to want the same lawyer to represent them in the same matter. For example, two people going into business together may want the same lawyer to negotiate their partnership agreement. Likewise, two defendants being sued in the same litigation may want one lawyer to represent both of them. While this would save money on costs, it does present a real challenge to lawyers because at some point in the file, the parties' interests are going to differ, and the lawyer is going to be placed in a position of a conflict of interest between those two clients. Finally, the law firm needs to ensure that the lawyer's own personal or business interests don't conflict with the client's. So, for example, if the lawyer is a part owner of a restaurant or is the head of an organization and someone comes in and wants to sue that restaurant or that organization, that will be a clear conflict of interest, even if it's another lawyer at the law firm that is representing that client. So, how do you know if there's a conflict? Every firm will keep a database of existing clients, previous clients, and businesses and other entities that lawyers have an interest in. As soon as you find out about a potential new client, and certainly before opening a file, as a legal administrative assistant, you need to conduct a search of that database to see if there's any potential conflicts. You should keep a copy of the results of that conflict search, even if it shows no conflict. That way, if a conflict is discovered in the future, you know it is because of an error in the database and not because you failed to conduct the search. If there is a potential conflict, you should bring that to the lawyer's attention as soon as possible, and they will determine if it's an actual conflict or if it is an exception to the conflict rules. To conduct the conflict search, you need to enter in the name of your potential client as well as any other parties to the matter. So in litigation, if your client is a plaintiff, you would enter in their name plus the names of all the defendants. It's easy to do this at the beginning of the file, but it's also important to remember that if new defendants or plaintiffs get added as the file goes along, that you need to conduct conflict searches at that time to ensure no conflict arises in the middle of a file.